Welcome. This is a very exciting time. Your business is on the go, and this is your new transition, your new company. In this presentation, I'm going to explain what it means to have a company. I will cover the requirements, obligations, and responsibilities of being a company director and owning your own company. Because understanding these basics will save you a lot of pain and aggravation later on. Think about how annoyed you get when you get a parking or a speeding ticket. Well, those fines are small fry compared to the costs of not understanding your company structure and directors' responsibilities properly. At the very minimum, it is a few $100s for something simple that could easily be thousands, hundreds of thousands, even millions. You might think, well, that won't be me. But unfortunately, we see it all the time in our forensic accounting work to people just like you. We want to protect you from that because in many cases, it would have been entirely preventable if they got the basics right. So in this quick 10-minute presentation, I'll be covering the compliance and regulatory essentials in owning your own company. It is to get you up to speed as quickly as possible. By producing this as a video, we ensure that we cover all the information. You can watch or listen to it whenever you like, and you don't have to pay for our time to explain it to you in a face-to-face meeting. So what is a company? Well, the first thing you need to know about your company is that it is a separate legal entity. It has rights. One way to think of it is that your company as a separate person. Whilst you own the company, you only own an interest in the equity of the company. You do not own the company assets. The company owns those assets. If you want to get money out of a company, you can pay yourself a salary, pay a dividend, or the company can make a loan to you. The loan has to be repaid with interest, and many people get stuck on this point, and it causes them no end of trouble. The rules of the company are set out in the company constitution. A copy is found in your company folder, and also the Corporations Act 2001. The constitution will set out what the company can and cannot do, how and what shares can be issued, how and who can be directors of the company, etc. A company has directors and shareholders or members, and they have different rules and responsibilities. Directors operate the company on behalf of the shareholders. The directors of the company can be different to the shareholders. The directors are people where the shareholders may be other companies or trusts with a trustee. Directors' duties. In the first instance, the duty of directors is to ensure that the company complies with the specific laws and regulations relating to the operations of the company. This would include tax law, environmental laws and regulations, occupational health and safety, and criminal law. But the primary duty of directors is to the shareholders of the company. The exception to that is if the business trades insolvently, the duty then expands to creditors, including employees. We'll deal with insolvent trading later on. The Corporation Act imposes further restrictions. 1. To exercise your powers and duties as a director with the care and diligence that a reasonable person would have, which includes taking steps to ensure that you are properly informed about the financial position of the company and ensuring the company does not trade if it is insolvent. What this means is you cannot rely on the other directors to take care of the company. You need to be involved as well. The silent partner argument does not work if you are a director. Second, the duty to exercise your powers and duties as a director in good faith in the best interests of the company and for a proper purpose. What this means is you don't treat the company assets as though they were yours personally. They are the company assets. Another example, for example, selling or transferring company assets to another entity at less than market rates can result in corporations law problems as well as tax issues. 3. The duty not to improperly use your position as a director to gain an advantage for yourself or someone else or to cause detriment to the company. We see this quite often when one director takes, say, the company database and sets up in competition, or uses their role as company director to get a better deal on, say, building materials in return for the supplying charging the company more for the materials. 4. The duty as a director not to improperly use information obtained through your position to gain an advantage for yourself or someone else, or to cause detriment to the company. The most obvious example here is insider trading. The duty to not trade whilst insolvent. As well as the general director's duties, you also have a positive duty to prevent your company trading if it is insolvent. A company is insolvent if it is unable to pay all the debts when they are due. This means that before you incur a new debt, you must consider whether you have reasonable grounds to suspect that the company is insolvent or will become insolvent as a result of incurring the debt. Your company must keep adequate financial records to correctly record and explain transactions and the company's financial position and performance. A failure of a director to take all reasonable steps to ensure a company fulfills this requirement contravenes the Corporations Act. For the purposes of an insolvent trading action against a director, a company will generally be presumed to be insolvent throughout the period where it can be shown to have failed to keep adequate financial records. As a member or shareholder, you are not liable in your capacity as a member, as opposed to a director, for the company's debts. Your only financial obligation is to pay the company any amount unpaid on your shares if you're called on to do so. Most companies these days will not have any unpaid share capital. Insolvent trading. The company structure provides you with protection against creditors unless the company continues to trade whilst insolvent. In that case, the directors will be liable for the liabilities of the company. In other words, the protection is lost. Directors' guarantees. It is common for banks, lessors, and some suppliers to require a director's personal guarantee. The director guarantees effectively bypass the protection that a company provides directors of a solvent company. If you sign a director's guarantee, the creditors will be able to come after you, after your personal assets, in the event of a default. If you are, say, equal shareholders, the bank do not have to apply the guarantees equally. They could go after one director only and leave the other alone. Shareholders' agreements. If you're going into business with another person or persons who is not your spouse, you must have a shareholders' agreement. Most of the expensive litigation that we are involved with could have been avoided if a shareholders' agreement was in place. So what should a shareholders' agreement contain? What happens if everything goes well? How will profits be distributed? How will the owners get paid for the work that they perform in the business? What happens if everything goes bad? What happens with unpaid directors' wages? What happens if one party has to loan money to the company? How do you remove a director? How do you buy out another shareholder? A shareholders' agreement is about sitting down and having the difficult conversations now while you are friendly and cooperative with each other and agreeing on the rules if everything goes well and if everything goes badly. Remember, once you're in agreement, get the agreement signed by all parties. Too often I see litigation where the shareholders' agreement was never signed. ASIC notifications. You must notify ASIC within 28 days of any changes to directors, shareholders, shares issued, or the addresses of business. This includes changes to the residential address of directors. Fines apply if you are late in notifying ASIC. Now, we can take care of those forms for you. So if you've got a change of address or change of details, make sure you inform us and we can lodge the forms with ASIC. Taxation obligations. Your company will need to lodge an income tax return each year. In addition, if you employ staff, you will need to remit PAYG tax and pay superannuation for your employees. If you are registered for GST, you will need to lodge a business activity statements either monthly or quarterly. If you have any questions about the operation of your company, please call us.